Number 21, Admiralty, 29 of 22.
May I please, Your Lordship? Mr.
Oh.
Vakil, not
I have not received the papers of this suit.
paper book is not there, Your Lordship.
Sorry?
Paper book is not there.
No, I have not received the paper. I think possibly I have not received from the registry. They are searching for it. Can this be posted beyond vacation? Can it wait for some time, or is it so urgency?
100%.
Can it let it wait because demolition is to be given priority over the Admiralty suit? Are you from somewhere else?
Yes, sir.
He's from out of station. No? They are from Chandigarh,
Yes, I'm from here.
Which date you?
but they like to visit Ahmedabad, so my lords can give another date.
Lord, it's all
You are
courtesy.
most
Lord, it's all
welcome.
courtesy, my friend. Lord, we can get. Lord, it's all courtesy, our
Justice is
senior friend.
delivered everywhere, wherever the courts are. There is an institution. This is meant for justice. So, what is beyond vacation?
Not any date, not that suits your lordships. Not if an order could be made, that it would be heard on priority. Not I have few submissions to make. Not before your lordships give a date.
Just brief idea what
Not
the-
brief idea. Not brief idea is that not we hired a ship for bringing a part of our machinery from
you are representing.
The
not
plaintiff.
the plaintiff. Your Lordship,
Plaintiff,
plaintiff. We hired a ship not for bringing our machinery from China to India. Not, but a part thereof was coming. It would last and packaged properly. Not when it reaches Mundra port. Not they tell us that not due to another container which has hit our machine. Not it has moved. Not so instead of not giving us money because our machinery which is around $8 lakh, not it has been damaged. Not they say you please pay us. Not because Mundra port is asking us money because we got delayed offloading your cargo.
Who represent Mundra port?
Not Mundra port is not a party.
No, they are not asking.
Not we are not claiming anything against Mundra port. Let us be very clear.
Yes, they
Not
are.
what we are saying, not now what, after filing of this suit, not we when we initially filed this suit, not we very well said in our suit that not our cargo has yet not been delivered to us. Number one, it may be delivered to us. We will be ascertaining the damages caused to our cargo and then we will be making our claim. Lord, on the very first day, an order was made that the amount, whatever they are asking, you please pay it and it will be, you can ask for it later on, Lord. We paid the amount, we immediately moved our application saying that we want to bring it on record that we have paid that amount. Thereafter, Lord, the amount, our cargo is released, Lord. In the meantime, they file a 711 application. We get our machinery, Lord, we assess the damages and not we quantify our damages and suitably not we move an application for amendment of our plaint saying that this is the final damage caused to our machine and we want to have this amount from them. Lord, in the meantime, they have already filed a 711 application saying that we are an agent of a foreign principal and Lord, they have wrongly impleaded us. Lord, the foreign principal,
So
Lord, he served
the
upon.
damage caused by them.
Sorry?
The damage is caused by
By the shipper.
By the shipper.
By the shipper. Evidently not because it is a letter. It is a
No,
letter.
this is their case, but it's
Yes.
okay.
But it is a letter of the Adani port itself, who was an independent party, saying that this X number of container has hit your cargo,
Understood.
and photographs are
So
there.
today what is
I may indicate.
Not what I.
No,
So what I am saying is not what I wish to say is not. Since 711 application has already been moved, not we have on their application saying that they are not the principal, they are the agent of a foreign principal. We have impleaded the foreign principal. Lord, the foreign principal has been served. Lord, an order needs to be passed to tell them to please file a written statement so that the suit can proceed further, Lord. And Lord, this matter, Lord, except for our cargo getting released and not we completing the pleadings.
Principal and you, there must be some agreement between you
There's
and
no agreement. I mean, what really needs to be decided, Lords, where my learned friend indicated, the plaint which was filed on day one, the main relief, it read as pending the suit, something XYZ relief be granted.
So I can read it. I can read it.
I'm just indicating.
just orally. I don't have the papers.
So, after that, we filed our written statement because there's a time limit in commercial suits for the purpose of filing a written statement. All the defendants filed the written statement. We also moved
That principal has been joined as he has filed a written
no, they
statement.
made an application for implementation.
He has been
I
served.
just indicate.
He has been served.
What happened was thereafter I moved an order 7 rule 11 saying that I am not a necessary party. There is no cause of action for me. So the
You are the
I am defendant number 3. The
Vessel?
no, not the vessel. Vessel is not a party in the litigation.
Not he
I
says
am
he
the
says
manager.
Lord, he says he is an agent of the foreign principal.
he is
Practically, he's saying this.
I am defendant number 3, OOCL India Private Limited. So I said I have nothing to do. The plaint quam is liable to be rejected for XYZ reasons. After that, they move an amendment application. They move a second amendment application. Then there are 2 or 3 amendment applications by which they want to now improve upon their prayers which were filed in the plaint as was originally filed, which is in widespread submission will frustrate my Order 7 Rule 11. The moment I file an Order 7 Rule 11, my right to have the application heard first before their amendment, because their amendment is rectifying the defects which I am trying to point out.
Understood.
In the
So that
meantime,
is the procedure to be
yes.
followed. But
In
how,
the meantime,
against whom they would raise their claim then?
huh?
Against whom their claim would lie?
Lord, he
will
would
lie
prefer against nobody.
Yes, yes.
He would prefer against nobody.
No,
In
because
fact,
there
in
is some
fact-
damage to the.
That is there.
So there must
but
be
in-
some agreement between you and the
No,
principal.
no agreement. That is why now he wants to join somebody else. Let me assume the principal. I was supposed to be the agent of a disclosed principal who is a foreign party. So now they want to bring in the foreign principal. So obviously both can't be
So
there.
there his
So-
prayer naturally would be either you pay or he pay.
No.
The claim, whatever the damage, that's what his case is.
Yes,
I'm
yes,
not
yes.
saying that, but that his case is that in view of the damage caused to the machinery and there being some damage caused to
So
that.
please, Lord, the first thing my Lord will have to address is such a
7-11.
plague maintainable.
No, Lord,
And
just,
in fact-
I am the
in
dominus
fact-
litis.
In fact,
I am the dominus litis. I am the master of my pleadings and master of this suit also, Lord. How can he say, you please argue this first? Lord, what I suggest
I am
is,
in fact, I
what I
have
suggest is,
already moved an application. My application is on the way. That in the facts of the present case, my Order 7 Rule 11 will have to be heard first, because there are 3 amendment applications pending from his side.
Understood.
There is one implement
So that
application
your
pending.
that application otherwise would become infructuous.
Infructuous.
So, but the there is no arbitration clause in
No.
such a situation.
Lord, just 2 things that I wish to mention.
Yes.
2 things. Lord, as of today, Lord, as of the law stands today, the Supreme Court, Lord, is very clear that, Lord, amendment to pleadings cannot be stopped. Number 1. Number 2, Lord, an application under section 711 has to be decided on the basis of the plaint and plaint only. Whatever has been said in the written statement cannot be looked into. His 711 is purely based upon his WS. Nothing beyond it. Lord, I say with authority at my command, Lord, and at the bar, that, Lord, in the plaint, Lord, whatever he is basing his application under Order 7 Rule 11 is solely based upon his WS, not on the plaint. Lord, so what I suggest is, Lord, if you
What is your maritime claim then that is to be decided.
Lord, maritime claim includes a claim for damages to the goods. That is very clear. Lord, I have brought 2-3 judgments also, Lord, to that effect. Lord, what I suggest is,
We will
Lord,
argue Order 7.
Yes,
Yes,
Lord.
my Lord will reject it.
yes.
My Lord will reject my application.
Or may allow it,
I have
also.
broadly understood the issue so that I
So,
can look
Lord,
into it.
if I may suggest, Lord, kindly have it on a Monday or a Friday, which is convenient, Lord, so it is easier for us to travel, Lord.
Yes, we'll take.
And on a date, Lord, which my lords can indicate that, Lord, it would be taken up for priority, Lord, because it is a 2022 suit, Lord. Nothing has substantially happened in it, Lord.
Accommodate you in somewhere in December.
2nd December is a Monday.
2nd December is a Monday.
2nd December.
2nd December.
If it suits your lordships, and if your lordships could indicate in the order that, Lord, it will be taken up on priority, Lord.
You that I can't because I don't know my roster whether it will continue.
But
or
at least
not.
if your lordships could mention it, indicate it in the order,
Might
would it be
request
easier for us to
extend
make a
that.
mention a lordship on that day?
And
आज ये order
from who?
क्या थी थी
Yeah, from
In Hindi, please.
you represent whom?
There are no papers of
Suppose the defendant he wants to implead. He has filed another application that he wants to implead me. Now he says I am the carrier. That is his application.
He is
Why
the
not?
forum principal. He is the forum principal disclosed by him.
So that is.
So are you denying that fact that you are not one of the
I'm
carriers?
saying I'm not a necessary party in the suit that he has filed the way it has been filed. Because the suit that he has
But assuming that without going into any
Yes.
legal aspect,
Yes.
keep the legal aspect
Yes.
as of now side apart. Just simply take that example that he has some claim because he received the machinery, which are the damaged machinery. Where would his claim lie?
his claim would lie against those properties who have supplied in that machinery in the sense that probably the
Principal.
China supplier.
But
Just a minute. China supplier might have contacted some agent through which it has been supplied. There must be some contract entered into between the main supplier being the China supplier and his agent, through which it has been directed to be delivered at Kandla port.
Yes.
So there must be some intermediary
Yes.
and there must be some
Absolutely.
agreement
Not-
entered into between the parties. Is that on record?
No, that is not.
Not everything is on record. But what I'll show is,
If it was, because the Lordship has put me a question, I must answer it. In the plate, if there was an agreement on record to include me as the person who's to be liable, then the suit would have been filed against me. The suit has been filed against Mr. Vakil's client and others as if that they are the persons who are responsible for the damage and they are to be paid. Now they have invoked the Admiralty Act to say that it's a maritime claim and therefore the entire act is invoked to say that the vessel etc. is to be liable. The carrier, the vessel
You are a carrier.
Yes.
You are carrier.
So therefore now the invocation of Admiralty Act itself while filing the plate, Mr. Vakil's application is that this suit, the way it is there, is not maintainable and the provisions of Admiralty Act cannot be invoked. Now, if therefore his application for impeachment is there, in fact, on last occasion, my learned friend may say that that he was to be withdrawing the suit and filing up fresh. He took time.
huh?
It is all of us were here.
That I took time
All of us were here.
for withdrawing the
All of us were here.
Long back, about
But
a year back,
we are-
about a year
But I-
back when this aspect
Lord,
was
thank
not
God for
a-
YouTube, Lord, thank God for
Yes,
YouTube.
yes,
But it is already
yes,
on YouTube.
Anyway,
we showed
let's now. I've understood that what
Yes.
is his claim and how it
Yes.
is. So 2nd of December, I don't have the paper, so let's understand between
Second
that with
December,
the
your lordship. Will do.
understanding between the parties. Paper male tare lagjo.
Not just one more thing, what my friend was saying, not out of context, not there is a loading survey on record. Now, loading survey is not at the stock warehouse of the manufacturer. Not a survey is got conducted in China. Not it is a statutory provision. You have to get a survey done before something is shipped out of China. Not so at the manufacturer's facility, authorized
There is
person.
survey report.
Survey report,
That they are
photographs,
intact, yes.
everything was intact. Number one. Number two, Lord, the bill of lading, Lord, which is the most important document, says that everything was received in order. Lashing was there, properly lashed. It is in the bill of lading. And Lord, during the course of argument, Lord, I will be, with the grace of God, able to show that not through the pleadings only, that not both these respondents are in collusion. One saying that he is liable to pay, one saying his other is liable to pay. Please let me out. Not whom I am to blame. Lord, $8.25
Then
lakh
why
machinery is
principal
damaged.
supplier- Why your principal supplier is not coming forward?
Lord, principal supplier, I don't have a claim against him, Lord, because it was properly lashed. If everything, there is a survey.
That's yes, there is a survey.
There is a lading bill of lading saying everything is
And
intact.
the vessel was arrested at
No,
that
no, Lord. It was not arrested.
It's not arrest the rest. The rest is not here, my lord. My learned friend.
It's an action in
It's an
person.
action in person. Therefore, he has to file a suit against. But that will.
No, I'll show that.
2nd of December time being, because as and when the papers are received, I'll say that by jointly, on account of paucity of time, let's put it this way, that on account of paucity of time, the matter is adjourned to 2nd of December.
Obliged.
Lord may indicate something about not that. It may be taken upon.
How can
Right.
I assure on that? I don't know the.
Lord, I'll make a
Probability
mention.
on
Lord,
what
I'll take the
happened
liberty
on
of making
2nd
a mention on that, Lordship.
So there is no certainty for tomorrow. How can I ascertain for 2nd of December?
Obliged.
Yes, please.
We're grateful for your Lordship's time.
Grateful.
So 22 is adjourned as mentioned, 23 of
And
the